It is 6:01, and I'd like to open the regular planning board and public hearing meeting of the planning board for Tuesday, March 25th at 6:01. Under Mass General Law, Chapter 30A, Section 20F, this meeting is being videotaped and going out live as well. First items are administrative, and the first one is Private Acres, also known as Walters Way, file number 99-005C. Release the surety balance to the town of Westport to complete the subdivision project abandoned by the developer due to default.
So the planning office is going through some of our old files and trying to tidy up some loose ends. This one being a case from 1999, obviously it's been outstanding for quite a while. This was a project that received approval in the early 2000s, and the developer has subsequently gone bankrupt, is no longer in play with continuing the development anymore. So we wanted to talk about what options the planning board has if a subdivision developer defaults. So there are three different options for the board. The board is not legally obligated to take any action. That's option one. Option two is that private abutters, so the folks who currently live in that development, can take over the completion of the subdivision. There's a process for that we can talk about. And option three is that the planning board can seize the surety and then use that surety to complete the subdivision's infrastructure. This does come with a couple of different caveats that it has to become a public road. The chairman and I had discussed earlier today that he thought that this was a road that is functionally equivalent to a rural residential lane, which would typically have a covenant restricting its ability to be transferred to the town. I didn't have time this afternoon to look into that, so we'll follow up on that piece to see if it's even could be taken over by the town. But we also have to, the planning board would have to find the developer in default. Then the town, so the select board, would seize the funds. The road would go to town meeting, and again, as long as there isn't one of those covenants that have been filed. And then the town would then use those funds to complete the work. I think one thing that's important to note with that is that because this is such an old subdivision and the surety that was taken out for this dates back to about 2015, I doubt that what is held by the planning board is going to be able to cover the costs to complete the road, as well as there's going to be general maintenance that's going to need to occur on this site as well. That's been that the developer never accomplished when they were working on the subdivision. And so in which case, if there's a shortfall in those funds, the planning board can either, or the town can either go to go to town meeting to ask to use the town's general funds for general revenue funds to complete that roadway, or assess a betterment on those affected within the subdivision for the new improvements. And so Dia's going to talk a little bit about what our recommendation is for right now with this situation.
Yes, so staff does recommend option two, that the homeowners, the residents of Walters Way, take over the completion of the subdivision. Regarding more concrete next steps, we'd have to check with town council, but it is understood that the residents would first complete the work to the board's satisfaction and then receive the surety back, which the surety held is $24,000 and with interest is $24,791.
And we have, I think the last time that our consulting engineer looked at this, what did they opine it would cost to complete? Do you have that?
Give me some time. I had it.
At the time when this was last being considered, and I think it was about 2020, the town planner at the time, who's now the town administrator, Jim Hartnett, thought that it could be accomplished with the funds that were available. However, he did note that it would be a very, very tight budget to complete it. So he thought it was possible at the time, but given the fact that he thought it would be a tight budget 5 years ago, I think it's going to be more of an issue now.
Well, it might cost us more to do it than it would the property owners.
That's correct, yeah.
If I recall back, it might have been 5 years ago, Jim Horton and I and Manny Soares went and walked on the property and looked at what was to be done. And I think that one of the consultant engineers that come before us occasionally was going to draw up a plan to do it, that we could put our approval on the plan, even if it was slightly different than the approved subdivision plan. I think that was Mr. Gordowski. And I don't know if we have a copy of that, but I think, and tell me if this is the proper thing, but I think we ought to make a finding that he is in default first.
Right.
Is there a homeowners association?
There's no homeowners association
It was
in place.
before it was required.
So is there an entity we could release the surety to?
The neighbors.
Yeah, but the neighbors,
There's no entity.
so there's no entity, so you don't write a check to the neighbors.
Well, I don't think we could write a check to them. They would have to complete the work,
Yeah,
send us a report that they've completed the work, and then we could send it out, and they could tell us how it's divided, you know,
Right.
who put
you
money
mean
in.
we pay the contractors bills that they would submit?
No,
No.
we would pay them for paid contractor bills, the homeowners.
They have to incur
They
those
have to.
expenses before the
So
town.
presumably, one of the homeowners would step forward, hire the contractor, pay the bills.
There was an effort 5 years ago to accomplish this.
Yeah,
And at least at that time, they could never get all the homeowners to agree.
right.
So our other alternative is to do nothing.
No, I don't want to do
So,
nothing,
I
I'm
don't
just trying to
either,
figure
but I'm saying
out.
that is one alternative
Yeah.
that we could do.
I'm in favor of doing it, I'm just trying to figure out, and I like the recommendation you've got, I'm just trying to figure out mechanically, without a homeowners association, how is this going to be organized? Is it likely we're going to deal with
Right.
a leader of the neighborhood?
I think for now, we should leave all three options open, but start to investigate option 2, which is
Yeah.
to send out a letter to the residents of this neighborhood to have them come to a planning board meeting or have, some designated representative reach out to us, who we can then interface with to try to get this situation fixed and have the roadway completed. So I think before we even start thinking about coordinating that
Yeah.
payment, let's see if it's even possible.
So, Mr. Chair, would we want like two motions, one to find the developer in default, and then a second motion to request that the neighbors come forward to us with a proposal on how, if we were to release the surety, they would go about undertaking the work?
If they could, and then I think we need to enumerate the third option, which is the town do it, and then charge everybody a betterment for the difference.
Yeah. but
And
we'd
I
hope-
think it would be more expensive that
Yeah.
way. So I think we need to outline that, and I think that Michael
Mhm.
can reach out to them
Yeah,
and do that. But I think the one thing we need to do is find the developer in default.
Mr. Chair, I move that we find the developer of Walters Way in default.
Second. Second.
Is there any discussion? All those in favor?
Aye.
Aye. I
Do
don't
you open
think-
to a second motion?
Sure.
Mr. Chair, of the three options that the planner has presented with us, I move that we try and develop the second option, which would be to have the homeowners undertake this work with the proceeds of the surety, and to reach out to them to figure out, given that there's no homeowners association, how that would happen.
Right.
Mhm.
That's a motion. Wordy, I'm sorry, but that's the motion.
You got that? Okay.
I second that.
All those in favor?
Aye.
Okay, next up is Francis Estates, file number 24-037C, Form C, endorse agreement to extend the 135-day definitive subdivision review period.
Yes, so the public hearing for the current Francis Estates plan and the rescission for the previous open space residential development plan for Francis Estate are on the agenda for the April 22nd planning board meeting. We need to continue to April to allow for time to publicize the notices and for the rescission, and we'd like to have both of these hearings on the same day, hence the extension. The extension actually does go to May just to provide a time buffer.
To May what?
May 22nd.
Okay.
Do you have the extension? It should be on the extension agreement, Nadine.
In that blue folder.
Oh, there you guys go.
Oh, sorry.
I'll be back.
Well, we can't make a motion with Nadine gone.
I don't think we need to make a motion on
Oh.
this. We just need you to endorse the
Right.
agreement.
So you don't need a motion?
No.
Okay.
It might be May 20th. Thank you, Nadine.
So we just need
Yeah.
to sign this?
May 20th. Thank you.
So we're extending the time for this Francis Estate until May 20th. Next is, we need approval for the assistant planner to be able to endorse approval not required or A&R plans. So I'd like a motion to that effect.
Mr. Chair, I move that we approve the assistant planner endorsing approval not required plans.
Second.
All those in favor?
Aye.
And we need to authorize the assistant planner to sign payroll, invoices, and vouchers on behalf of the planning board.
Mr. Chair, I move that we authorize the assistant planner to sign payroll, invoices, and vouchers on behalf of the planning board.
Second. All those in favor?
Aye.
She's taking over the planning board, huh?
Yeah.
Whoa, how long you been here?
Watch out, yeah.
Yeah, I know.
Next is Mellows Way, file number 23-028 SPA-LIV. Review of SW Toll Site Inspection Report dated March 14th, 2025 for an after-the-fact, low-impact development approval.
Mr. Chairman, it's actually 6:15. If we could move to the Marcotte rescission public hearing at 6:15.
Okay. Next up is the 6:15 public hearing for the Marshot subdivision rescission, file number 23-031C. This is continued from February 11th this year to consider rescission of definitive subdivision plan constructively approved for the definitive subdivision entitled Plan of Land at Assessor's Plat 52, Lot 20A, Westport, Massachusetts, and located between 278 Drift Road and 312 Drift Road, map 52, Lot 20A. On February 11th, the planning board voted to conditionally approve the modified constructively approved definitive subdivision. One of the conditions of approval was that we required review of the March 25th planning board meeting the applicant shall provide consultant review fees to pay in full peer engineering review services to confirm VHB's traffic analysis. This was a condition of our approval of the amendment to the constructively approved subdivision. Per this condition, and at the request of the planning board, staff contracted with SW Cole to review VHB's traffic analysis for accuracy. SW Cole concurred that the performed traffic analysis was accurate and appropriate in design. The purpose of the March 25th meeting is to consider rescission of the constructively approved plan if SW Cole could not verify VHB's analysis of the traffic study for accuracy. As SW Cole has approved the report with no further findings, the planning board must close the public hearing and vote on the rescission of the constructively approved plan. So, do I have that right, Michael?
Yep, you got it.
So we should make a motion to rescind the constructively approved plan. A vote yes would mean that the applicant did not meet condition 3 above and indicating that SW Cole did not verify the results of the study. A vote no would mean that the applicant meets condition 3, therefore allowing the board's February 11th approval decision to stand. So this is a public hearing. And first, I'll open it to the board, and then to anybody in the audience that would like to speak or ask a question.
Well, I'll start. I was not at the, full disclosure, I was not at the February 11th meeting, but I did review the video of the entire proceedings, and I read the minutes from our planning board staff. So I am qualified to vote. Let me put it this way. I have reservations about the usefulness, I guess, of the traffic study. However, however, the bigger issue to me is if we, and if I have this correct, if we vote to not to rescind our original denial of the 9-lot subdivision. Then they subsequently submitted the 7-lot subdivision. So that supersedes the 9-lot. Is that correct?
It's almost correct. So
Could.
it's in effect, that's what it is, but it's a little different. So after we denied the 9-lot subdivision, they were able to file a constructively approved 9-lot subdivision because we made a clerical error.
Right.
So when they came before us, they made an effort to amend the constructively approved plan. So we have on the table a constructively approved plan that, per this verbiage here, amends it to 7 lots and eliminates all of the waivers except for the one.
Yeah.
So if we rescind it, everything is rescinded, both the 7 lot and the 9 lot. If we rescind the amended 9 lot subdivision that's constructively approved, and we have already agreed to the amendment to bring it down to 7 lots.
Right.
So what I would like to do is to have a motion to rescind and then vote, and perhaps it's voted no, which means that the 7 lot amendment stands.
That
Per
stands.
our agreement with them at the last meeting.
Right, and the 9 lot is off the,
It's
is
amended.
superseded.
Right, it's amended.
Yeah.
So it's amended to 7, so you had it pretty close, but it's complicated. So-
Well, yeah, all right. Well, I have no more comments at this point.
Yeah. Anybody else? Okay, anybody in the audience?
Hi, I'm David Dorsky. I live at 11 Fallon Drive. I'm in a abutter and a student of traffic patterns on Drift Road. You initially voted to deny this proposal to a large extent because of concerns about the safety of the Marcotte Drift Road intersection. And you denied the request for the waiver of the requirement for a 25-foot turn radius at the southern corner out of this concern for road safety. You have to face facts. The average vehicle speed on Drift Road is 42 miles an hour by my measurements, meaning that half the vehicles are faster than that. Understand that if you allow the developers to go through with their proposed construction, there will be traffic accidents at the Marcotte Drift Road intersection because the sight distances are too short for the prevailing traffic conditions. You have to prioritize road safety based on prevailing conditions. Now, forced to reconsider that decision by your clerical error, at the last meeting you entertained the testimony of a witness provided by the applicant that purported to demonstrate that the proposed intersection would be safe if you grant the waiver. The witness is an employee of the Van Ness Hangen Brustlin firm that is currently being sued by the state of Rhode Island for its role in the Providence-Washington Bridge crisis. That witness is neither a licensed civil engineer in Massachusetts, nor is he certified as a professional transportation operations engineer. Yet you accepted his testimony. You referred to him during the meeting as a traffic engineer, and he did not correct you. As an expert witness, he wouldn't survive a Daubert challenge if there was ever litigation in this matter. Then, one of your members suggested that you employ a qualified firm to provide a peer review of the applicant's witness's testimony. But you chose S.W. Cole, a respected firm that, however, performs only geotechnical engineering services. I wrote to the S.W. Cole firm asking if they offer civil engineering services involving traffic assessment. Their vice president, Dave Dunning, wrote to me, quote, "No, we focus on geotechnical engineering." If you're going to make decisions involving Westport road safety, don't you think you should consult licensed civil engineers with certification as traffic engineers? Perhaps you should take a step back from making a regrettable mistake and reconsider what you're doing. The legislative intent of the statute that allows for constructive approval is to prevent planning boards from freezing the consideration of proposals. You did nothing of the sort. You never unreasonably delayed any aspect of this process, and the applicant agreed to every postponement without any complaint. You are entitled to and should rescind the constructive approval that the applicant is now holding over your heads like a sword of Damocles. The action is defensible. Please do the right thing. Thank you.
Thank you. Is there anybody else? Any further comments from the board? Yes.
Comment, just here for the record, Attorney Christopher Alvin from Jonathan Silverstein's office for the applicant. Just wanted to make sure that the board knew I was located and I was here. Just responding to those comments, there was a traffic report and there was peer reviewed by town consultant, and that's our only response to that.
Mr. Chairman, I didn't catch the attorney's last name.
Alvin, A-L-P-H-E-N.
Can you say that a little slower, please?
Yep, A-L-P-H-E-N.
Thank you.
Okay.
Jim, excuse me, then, just one more clarification for my own benefit. If we vote yes to rescind this, this constructively approved plan, then where are we?
Probably in court. Because the constructively approved plan has been
Has been filed.
rescinded, which is our want, we can do that. They can reapply. They can bring it to court and say that we rescinded without merit. They can bring it to court and say we were in error. They can do a lot of things. The question is who would prevail, and I don't know.
Yeah, and then are both options open to them? They could file to have the original 9-lot subdivision
Well, if
reapproved, or?
They have that approved.
Yeah, but then we
amended it.
They amended it.
They agreed to amend
We
it
amended it on the
on the 11th. So we amended it when you were gone. And I think that was done properly. The only stipulation was that we said, as part of the approval, that they must pay for, the applicant shall provide consultant review fees to pay in full peer engineering review services to confirm VHB's traffic analysis.
Yeah.
They wouldn't pay for us to hire a traffic engineer.
But if we go to court, are we then being asked to reconsider or being asked to reinstate the 7-lot subdivision, the most recent one?
I don't know. I don't know if it's the 7 or the 9.
Yeah, Mr. Chairman, just to add the effects of voting in favor of rescission, we would argue that you don't have the legal authority to do so because we recorded a mortgage on the property, and after recording a mortgage on the property, a rescission is no longer legal. So to the chairman's point, if there was a rescission, there would certainly be litigation that follows, unfortunately.
So if you're referring to the mortgage that was put on the property the day before, This or a different mortgage you're talking about?
I know that there was a mortgage recorded, I'm not sure what was recorded.
Right, it was done the day before
Yeah,
they filed this.
I think that
And
sounds
it
right.
was,
Yeah.
a way to tie our hands, basically. I mean, it wasn't to fund whatever's happening there, in my opinion. So, if the property has been amended, has the mortgagor approved the amendment to this plan?
That's not necessarily required, so you can amend.
So why would it be required if we rescind today?
Well, the statute says that after, take a loan on a property, you can't rescind a subdivision plan. But to your point, and to the chairman's point, if there was a modification, that's recorded, that's the vote that was at the last meeting, was for that. So that's what's controlling, and all we're asking to do is not eliminate the vote that just happened last week, or last meeting, excuse me.
Yes.
Certainly, we've taken a lot of time on this development that was proposed at 9 lots. I've criticized the layout of this development. We have changed or proposed changes to our zoning because of the layout of this. We have encouraged an alternative that we thought might make the developer as much money with 4 larger lots. We've gone back and forth in so many meetings that I lost track a long time ago. Throughout this, I think we have consistently felt that the issue here is safety, whether it's 9 lots or 7 lots. It's, when one car goes from the driveway out onto Drift Road. This driveway is not the only place in the neighborhood where a driveway serving a number of houses enters out onto Drift Road. Amy Way, Fallon Way all have lots of houses that go out onto Drift Road. There is a circumstance here of a curve, and we have talked, certainly at the last meeting, a lot about what can be done to improve the sight lines of this by cutting back brush, by elevating the road, by doing everything possible on the issue of safety. And I think the discussions with the developer in terms of moving the road, elevating, cutting back, all of that, cutting back trees on public way, I think is our responsibility. But it's all been around safety. And this decision, to me, boils down to not what I want. What I wanted was 4 lots, but, are we gonna get 7 guaranteed, or if we don't do it, are we gonna get 9? And I think 7's better than 9. And I know denial will make us all feel good for, it's like a sugar high for about 10 minutes until, we lose in court and then we eat 9. And it just, I just think that's not in the public interest. So I'm gonna go with the chairman's recommendation on this.
Mr. Chairman, I just, for the record, I think on the 11th, I moved to amend the subdivision. And just for the record, the memorandum we got from VHB was actually stamped and signed by a professional engineer and a certified traffic professional. And I have it here on the screen. Yes, the person who presented the report may not have been a certified traffic engineer, but the actual memorandum of the record was certified by a traffic engineer. Voting to rescind the subdivision and it just is playing for everyone to lose. As the town loses, the town faces a lawsuit, the neighbors get more traffic, 9 houses versus 7 houses. I see no benefit in from where we are now, particularly since our ability to actually rescind is limited under the law once lots have been conveyed or mortgages have been placed on the property. So my vote will be, as we have structured the motion, will be no on the move to rescind the subdivision.
So we have a 4-page review by S.W. Cole of the traffic engineering study. And while they are not traffic engineers, they say that many, if not all, engineers understand and have taken courses in this when they got their degrees. And he finds no problems with the traffic engineering study. And as Mr. Daler said, it is signed by a registered traffic engineer.
You want a
So-
motion, Mr. Chair?
Sure, if we're done talking.
First motion would be on the closing of the public hearing.
Mm-hmm.
Yes.
Mr. Chair, I move to close the public hearing for the Marcotte decision.
Second.
All those in favor?
Aye.
Aye.
You want a second motion, Mr. Chair?
Yes.
I move to rescind the constructive approval of the definitive subdivision entitled Plan of Land at Assessors Plat 52 Lot 20A, Westport, Mass., also known as Marcotte Drive. That's my motion. Even though I make that motion, it's my intention to vote no on that motion.
I second the motion.
Any discussion? So, all those in favor? All those opposed?
No.
No?
No.
So, that is it. Thank you very much.
Thank you.
So back to administrative items. E, Mellows Lane, file number 23-028 SPA-LID. Review of SW Cole site inspection report dated March 14th for an after-the-fact low-impact development approval.
Okay. So, yep, thank you for the introduction. This is for regarding Mellows Lane. Let's see. So, SW Cole made multiple site visits in February of this year, timed with rain events to assess drainage. No evidence of flooding or standing water was present on site. No overtopping of the laneway or the berm. Frost was observed, though the depth was not noted. So, SW Cole recommends an additional site visit when the ground thaws. Staff is okay with that recommendation, also doesn't really see the need for additional site visits.
And for the record, we haven't received any complaints since the modifications have been made regarding drainage into the adjacent subdivision. As Dia had said, Derek Miller went out to the site, and the snow, it was it was like a 38, 40 degree day. The snow was thawing. He did observe it to be performing as it was designed to function. So if the board is inclined to release this, we just have to get some additional consultant review fees that the developer is in the red on, which we've reached out to them to get that taken care of, but that would be the last outstanding item. Otherwise, this would be closed out.
So in the report, he confirms that the minor modifications to the landscape have been made to affect this.
That's correct.
So I would like a motion to release upon receiving the back money that they owe us.
So what money are we releasing, surety?
It's a motion to close the public hearing.
The
We're
public
not in
the
a
public
public
hearing the public hearing has been closed, is to accept the consulting engineer's report that the drainage infrastructure is functioning as designed, and therefore not requiring a subsequent consulting engineer site visit, which was recommended in the report. So essentially, what we're asking the board is to say, yep, we're okay with this, this is functioning the way it was supposed to design, and then we need to then settle the balance that is outstanding with our office on the consultant review fees, and we'll get that taken care of, have the developer bring in a check, and then this will be able to move on from Mellor's Lane for now.
Well, I move that if you can translate that into a motion.
Sorry. Can make a motion to accept the consulting
Accept the
engineer's
SW
report.
Cole's report
and that
not require a second visit, and then settle up based on that.
I second that motion.
All those in favor?
Aye.
Aye.
Thank you.
Okay.
Could you tell me what the balance is, and I can help try and get that money to you? I know in the past, it's been a little slow in getting. I can check with you tomorrow.
Yes.
yeah, we'll send it
check-
to you.
yeah.
Yeah.
Next is 202 Pine Hill Road, file number 19-012 SPA-LID-S, request for partial performance surety release for a solar development.
So, on the last meeting on 3/11/2025, it was motioned to approve the installation of farm-type agro-style fencing at this solar development, which was a deviation from the previously approved chain link fence. So per SW Cole's surety estimate comments from February 10th, 2025, a surety reduction of $80,000 with the retention of $20,000 to complete the remaining work is recommended.
So I think just a point of correction, I don't think we're releasing 80,000
I
in
think
total, but the resulting would
Oh.
be
Yeah.
20,000.
Pardon me.
This report says reduce the 100,000 surety by 25,000, maintaining 75.
Right?
So the resulting balance that we need to retain is $20,000 for the landscaping.
But you already released 25,000.
Out of the 100.
Out of the 100, right?
So now we need to release 55
Mm-hmm.
and leave 20. I am going to suggest that we retain 40. And I think we should retain 40 on every account. It's more of an incentive to finish. especially when you have little things to do.
Mhm.
Mr. Chair, I move that we partially release $35,000 from the project known as 202 Pine Hill Road Solar, retaining $40,000 for remaining work.
Second.
All those in favor?
Aye.
Aye. Next is 541 American Legion Highway, file number 20-001 SP. Review of SW Cole Site Plan Inspection Report dated March 11th.
Yes. Thank you. So SW Cole inspected the site on March 11th this past year and listed outstanding items to be addressed, items to be verified by the building inspector, or items to be incorporated into the as-built. So I'm going to briefly just look through his report and make a couple highlight a couple comments. They say that an asphalt surface course should be installed. The lots need restriping. The health of the trees needs to be determined in 6 months. The signage for handicap parking doesn't meet regulations. Let's see. There's no current drive-up window on the building. The placement of the bollards are questionable near the gas meters and electric meters, which needs to be reviewed by the building inspector. Some of the flared ends of the culverts have debris that needs to be cleaned out. The original design plan calls for a cast-in-place level spreader, but precast blocks were installed instead with notches. The 6 to 12 inch riprap, which is specified on the plans, is not in place. The storage building to the rear of the property isn't defined. The original plans do show the structure, so it should be represented accordingly on the as-built. It's unclear where the roof drainage ends up. This needs to be clarified and noted if it's part of the design of stormwater. And then a large topsoil pile at the rear of the site needs to be removed. And lastly, catch basins should also be cleaned of all debris.
There's no action needed on this. We just wanted to provide an update on this project.
So there are also a number of outstanding permits with buildings, so the issuance of a temporary occupancy permit can't be recommended by planning board at this time. So yeah, we're just waiting for these outstanding items to be addressed, and we will touch base when
So
it's ready.
do we need a motion to inform the building inspector that we do not suggest issuing a temporary CO?
They're aware.
Yeah.
We've spoken with the building department, and they declined to allow them to apply for a temporary CO due to the number of outstanding items on the site.
Not just ours, but
Yeah.
they have a lot.
They have outstanding permit inspections that need to occur. Yep.
Okay. Next is 222 State Road, notice of violation for paving over 40,000 square feet without low-impact development site plan approval.
Yep, so the applicant paved over 40,000 square feet without low-impact development approval from the planning board. Building has been asked to enforce with a letter from the building commissioner dated March 19th, 2025, that dictates that the owner has 30 days to apply for site plan approval low-impact development or be subject to a fine of $300.
Okay.
So again, no action necessary on this. This is more of a heads up that this application will hopefully be coming into the planning board for, in particular, our concern is the review of the drainage. Apparently drainage wasn't installed on site. So that's a concern because we know that there are drainage issues along Route 6. We don't want that to be exacerbated with any new development.
So this is the bus parking lot.
Yeah.
Okay, you don't need a motion.
Correct.
Next is 0 Adams Hill Road, file number 25-004, SPA minor. Request for minor site plan approval at the property described as map 79, lot 21, adjacent to 638 Adams Hill Road for a temporary trailer used as a mobile food vendor.
Just a quick note about this.
Mr. Chairman, could I'm interested in this. Could I ask permission, please, to put my amplifier so I can hear what's going on?
Sure.
Thank you.
Is that close enough?
I think so.
Good
Yes, sir.
evening, Mr. Chairman. Greg Estabrooks, I'm an attorney with Kelly Souza, Parmenter and Resnick. We're located at 128 Dorrance Street in Providence, Rhode Island. We also have an office in New Bedford. I represent the applicant, Sarah Delano and Bruce Delano. They're principals of Delano's Daily Grinds. They're owners of the property. I submitted this application for minor site plan approval after coordination with the planning department and also the zoning officer on the permissibility of the use. Submitted a cover letter, application, that memorandum from the zoning officer, and site plans that you have on the screen here. They're as existing, so this is exactly as the property looks like today if you were to go out there. Food truck is currently there, situated towards the rear of the parcel, and the parking lot was existing. So just asking for approval of the minor site plan to keep the property as it's existing today. Happy to answer any questions you have.
As you're looking some things over, I just wanted to note that I did make the decision to waive a number of the typical submission criteria that we would expect from a site plan application. With this being a mobile food vendor, it's like 200 square feet. It's not really having that much of an impact, so we determined it was a minor site plan application, which is why the level of detail we would typically expect on a site plan application is not on this plan because we waived them.
So the parking area was constructed by Ralph Guild, I think?
Correct, yeah, the
The
predecessor
previous
in
owner.
interest, correct. And it was used for the coffee shop across the street as it is now, so.
Right. So you feel it's part of the coffee shop, really?
Correct, yeah, we view the use as accessory, right? There's the coffee shop, there's the parking lot across the street, which was existing and already used for parking for the coffee shop, and now there's a food trailer going in there that really just augments the existing uses. People were already going to the parking lot, they were picnicking, fishing in the pond. It's kind of a quasi-public use, right? Like, it services the coffee shop, but it's also open to the public, and we're fine with the public enjoying, you know, the pond and nature and having their lunch there. So the food trailer really just, it fits in with the existing use.
I saw it on opening day, you had a big crowd, but haven't seen it since. So I assume that this is part of the reason?
Correct. So just as a little more background, there was a cease and desist order issued by the zoning officer back in December. My office communicated and negotiated with the building department, Randall Bassett, the interim zoning officer. Eventually, as a product of those communications, he issued a memorandum that is in your packet that determines that the use is permissible, and therefore it alleviated the existing cease and desist.
Okay, so the parking lot itself is, you say stone, but it's like gravel. And it's probably permeable. It probably drains into the brook and the pond. On the pond side, it has an area of grass around underneath that tree, so that it is, I think it's fine the way it is. I mean, I can't imagine what you would do to it to make it more compliant.
Appreciate that, Mr. Chairman. It's very nice looking if you've been out there. It's all very clean, and you know, they did a nice job with it. So.
And really what's being applied for here is the presence of the trailer on the property and any appurtenant uses to serve that, not, you know, we're not really looking at the parking lot itself, just the trailer and whatever is necessary, like I said, to serve that use.
So I'm not sure what we're being asked for here.
They're looking for site plan approval. This is a use that the building inspector said needs site plan approval before the planning board.
Okay.
And is the trailer seasonal use? Or seasonal operation, or?
So it
Year-round.
is intended to be there permanently. It's used more in the summer, but as the chairman noted, I would say that goes more towards the use, right?
Well, you know, as long as there's no zoning issues, I mean, I'm completely supportive of small businesses in this town, and I know that my son, who lives in Los Angeles, comes here for 2 or 3 weeks. Has been a regular customer, like every morning. I don't know. He gets up and rides or drives to the daily grind. So I know it's a good business, and I'm completely in support of this. No issues.
So I think there is a zoning question.
Okay.
Even though the interim zoning inspector approved it, gave him a letter. Ralph is back, and he is given is that email to you or to?
It's an email that I received from him this afternoon disputing
that. So
right, but on this board, we don't weigh in on the land use and whether or not that's permitted under the
Well,
zoning
I'm just
bylaw.
getting to what
We
Mark
just look
said.
at the site plan
Said-
approval.
Oh, I think I have a copy
You have
of that,
that.
yeah.
So,
All right.
but that's not our bailiwick. So I would entertain a motion to approve the minor site plan.
So moved.
Second.
All those in favor?
Aye.
I do want to say that I do not like the daily grind because it was at the daily grind prior to your ownership that Mr. Daler and Mr. Whiten twisted my arm to join the planning board. And all my Tuesday evenings have never been the same since that visit to the daily grind. And I've never forgotten that cup of coffee.
Your grievance is duly noted, I will say. But I appreciate your time. Thank you.
Good, thank you.
That's a true story.
Yes, sir.
Yes, I guess this is not a hearing because it was turned into a minor
Right.
thing, okay? I would dispute that, and would I have an opportunity to speak?
Yeah, sure.
In concept, I have no
Could you
problem.
give your name? We
I'm
don't know
so-
who
I'm
you
sorry.
are.
I'm sorry. Yes, my name is Jerry Catino. I live on Petty Heights, and I am a member of the Board of Zoning Board of Appeals, and I am concerned. I'm always concerned about the bylaws and so forth. As some of you know, I've dealt with trying to craft some of the bylaws in town and so forth. So I have no problem at all with this, but I do have a problem with if we're violating bylaws. If you don't like the bylaw, get it changed. So I've got a number of questions. I am not aware of what I just heard you say. You got an email today from Ralph. He's back.
Yeah.
So I guess he could overturn the overturn. But in any case, there's a number of issues here. First of all, it was not mentioned that we have a legally posted, scheduled zoning board hearing on this tomorrow night. So I think you need to know that. It's my understanding that the applicant is going to request either apparently a withdrawal or whatever, but we do have a scheduled hearing. Another thing is we question Oh, by the way, the hearing tomorrow night is specifically an administrative appeal. It's not to approve this or not approve it. It's an administrative appeal to overturn Ralph's decision. Did Ralph do the right thing? Yes or no, with his original cease and desist. It wasn't really highlighted here, but this is a commercial use, and that's important. So that is what was to be determined tomorrow night. Now, what also is not been said is that when they appealed to the appeals board, they said that this use is tied to the daily grind.
Right.
Okay? That creates some issues. First of all, we're not certain of the legal non-conforming status of the daily grind. There's been a number of zoning board hearings about this property if you relate it to the property, to the daily grind across the street, which is what they're doing here. I have all of these related to prior hearings about this property. The last approved legal non-conforming use for the property across the street that this is being tied to was to sell fruits and vegetables. That was a long time ago.
That must have been a long time ago.
It was a long time ago.
I mean,
20s or 30s or something like that.
yeah, way
And-
before my time.
Yeah, and mine. So anyway, we want to take it fairly seriously that there are some questions. And now I know in the past, on occasion, people have come here first and gotten their site plan approval and then come to the zoning board, and sometimes that's not carried on as an allowed use, and that could still happen here. Okay, one question I have is whether or not the decisions and the discussions in these prior hearings before the zoning board, have they been reviewed by the acting building inspector? I don't think so. Or Michael. I don't think so. I did talk to Michael about this on the phone. So one thing I think I need to point out right off the bat is Michael told me that they, in these discussions that are strictly between the building department and Michael, nothing to do with the zoning board, they have been using temporary trailer as their rationale for allowing this commercial use. And the reason they came to the zoning, to the planning board is because the bylaw, as it shows in the book, says temporary trailer by special permit by the planning board in all districts except Stodd.
Except what?
Stodd,
Start.
the Stodd district.
Yep.
I have serious concern about that. I've had serious concerns ever since we went from narrative bylaws to just the table, because the table is very abbreviated, and we knew that all along. And that's why that table says, right at the bottom of it, that if there's any question, the narrative takes precedence over the few words in the table. I am personally pretty positive that temporary trailer never meant a commercial food trailer. There was discussion at one time about people whose homes got burned down and they had to put a trailer in their driveway to live in. while it was being reconstructed and so forth. I don't know if that's what the temporary trailer discussion, because I can't remember at town meeting that coming up. Nor do I remember it being discussed at a public hearing for the warrant at a town meeting by this planning board with a public hearing. But I am convinced that this planning board, or a planning board, would not approve without thorough vetting and discussion something that just says temporary trailer without any concern or discussion or anything like that. So I've asked Michael to find in your planning board records the origin of how that got into there, just in the table of use, if it is only in the table of use. I can't believe it could be, but if it is, I think we need to find that out. So I think there's a serious question about this. Now, we know that many, many people love this idea. Along with their application to the zoning board, they've got many, many pages of petitions signed by various people in the community and many outside of the community. The problem I had when I saw this was that it doesn't show the locus. It doesn't. It's relating it here, but not here, not with you, but they're relating it to the Daily Grind across the street, and it ought to show that. This ought to show that, and it ought to show all of the dimensions, you know, like a survey, and we don't see any of that. So there are some issues there. Okay. What is the definition of temporary trailer? Any idea? I don't.
There is none in the bylaw.
There's no.
What's that, please?
There is none in the bylaw.
Yeah, you've checked that out, because I'm also checking it out. But it had to come before the planning board to get on an town meeting warrant to become. So you've got some record someplace as to what, you know, how this got in there with only the words temporary trailer and not even a definition of it, okay? Let me just quickly say, I don't want to take your time. Yeah, so, you know, which warrant article, when, and what did the article say? How did the article, was it worded to become only temporary trailer in the table of use? So the table of use is not a great thing if we don't make it a little more precise. Anyway, so
Jerry, I have a couple of questions.
Sure.
The temporary trailer, is that the same mechanism that the East Beach trailers are?
No.
No.
Those are seasonal. Those are seasonal trailers, and that works differently. They're licensed by the selectmen.
Right.
Annually.
And the food trucks at the Buzzards Bay Brewery?
No idea, but you got to remember, a farm can almost do anything they want.
But they don't make anything that they sell?
What's that, please?
They don't make anything.
Who doesn't? The farms?
Buzzards Bay.
Buzzards Bay.
There's nothing in the beer except water that comes from the property.
Oh, that's a whole different issue, and that's been discussed so many times. And I would agree with you, but that's not related to this.
Why isn't it? It's a food truck in a
It's
residential area.
It's a farm.
So?
A farm.
But the farm entertainment bylaw specifically says that it's for the ability of the public to come and experience a farm experience, right?
Yep.
So
And
drinking beer
the
is a
event
farm-
has to be farm related.
So drinking beer is a farm-related experience?
Well, if the farm is producing, like you said, the water from there, the hops. I'm
don't
not
think you-
interpreting
I
that.
don't think you farm water, so.
Okay. That.
Originally, they said they were gonna use local hops.
Okay, is this a farm?
No,
Okay, so it's not related, because the
Well, it's-
farm,
but they're using that improperly.
I think that also. But that's never
And
been,
the same with the brewery itself. What's the brewery doing there?
yeah,
I mean, they're not using any farm,
yeah.
anything grown anywhere near here. Their hops come from upstate
From,
New York.
Right, okay.
Could I take this in a slightly different tack? You said at the beginning, Jerry, that if the zoning law doesn't have something that we want to have, then we need to change it.
Right.
And the zoning bylaws, you know, are stuff that the zoning board and we have been working on, at least as long as I've been on the zoning board,
Right.
on the planning board. And I think this is another example of that. If you look at other communities, food trucks are a desirable feature of the community. It is something that the community supports. So the zoning board might look at this with the first question of, is this something that we support as a use? I look at it and say, this is like a farm stand. This is a seasonal, kind of temporary thing. It happens to have wheels where farm stands don't have wheels. But this is a seasonal, you know, doesn't necessarily have a bathroom or bedrooms or anything else, but you sell food out of it. And, but it's not in our table of uses. Well, if we want to have food trucks,
Precisely.
and it's not in our table of uses, and we think that the people of Westport like this,
Right.
then should we define it? Okay, it's not a trailer that you'd find on Horseneck Beach, even though it might look like it. So how do you define it? And let's put it in our table of use and see if town meeting
Precisely.
swallows it.
Right. That's exactly it.
Yeah.
And that's my point. I think to do it here with, under the guise of a temporary trailer,
Well, the first one might be done as an exception, but, you know, is
Right.
this gonna be the last one?
Well,
Or
that's the point, because-
is this a good idea that you might find somewhere else? And so I think that, you know, it's conceivable that this is a good idea, and good ideas have a way of being copied. And if they are
That's
good
right.
ideas, they should be
Yeah,
copied.
yes.
And so we should find a way to define this and then get it in the table of uses.
That is absolutely correct, and that's what I'm saying, because otherwise you're destroying the integrity of our bylaws.
Right.
Why,
Yeah.
why have them
Yeah.
if we're not going to abide by them?
Yeah.
But I still go back to the point of this all, if this is an accurate depiction in the table of use, it had to come initially through the planning board before it gets on the town meeting warrant as a zoning article. And I'm just asking, let's look and find it. Now, I don't know legally how this stands. We on the zoning board have not had a meeting since this, have to discuss this. We hope to do that tomorrow night. But what's the legal status of Ralph's cease and desist? Does this temper, because Ralph happened to go out on a medical situation for a while, they appointed a temporary person to fill it. He and Michael have been discussing, and they overturned, they, not the zoning board, but they overturned Ralph's cease and desist by saying, oh, temporary trailer fits the bill, so let's just use that.
So just to be clear, it isn't they, it's the temporary zoning enforcement officer who did that.
Yeah, yeah.
I did not have any discussions with him about overturning Ralph's determination. In fact, I had expressed.
Right, I know you expressed concern about the fact that you doubted it. And so that's what I'm saying. I was just hoping that we weren't going to act hastily. Give us a chance to have the zoning hearing, see what comes out of that, and then go from there. And it may very well be as simple as you just indicated, well, not redefining, because it's not defined, but define things like temporary trailer. I mean, we know there's deficiencies in our bylaws, but this is a great big hole, as far as I'm
Well,
concerned.
it's a small hole, but it is a hole. So
Yeah.
we have spent, I don't know how many meetings going over the bylaw, and we have changed them, 3 years ago,
Yeah.
to consolidate them.
Yeah, I work
And
with you
it
on
doesn't
that.
mean that our job is done, but there's only so many hours in the day.
Right,
So-
you guys work hard at this.
So, but the thing is that we're not approving the use here.
Okay, well,
All
let's-
we're doing is approving the minor site plan.
Okay,
We can't, and so our decisions, we can never base our decisions on another board. We can't say, well, we'll approve your site plans if you get approval from the zoning board.
right.
We can't do
No,
that.
no, I understand that, and what I'm concerned about now is what's the legal status of the initial cease and desist, and then this temporary person changed that, and now I'm hearing that Ralph is back, and has he changed it again? I don't know.
But
So,
thank God, it's
okay.
not on our plate, it's on yours.
But anyway, but I just wanted to be sure that some of these things came up. A concern is people crossing that road, okay, from one side to another. You don't usually have a commercial activity that's dependent upon parking across the street, and that we have in that situation.
But Jerry, it's been that way for 20 years.
I understand, and until somebody gets hit, or killed there.
I mean, we didn't approve anything about
No.
that, so.
Neither did we.
Yeah.
Okay, and I don't know how it came about, but somehow the town was good enough, I guess it was the town, put a crosswalk there. So that's an issue too. By the way, Ralph Guild and his wife worked hard, spent huge amounts of money, all sorts of efforts to do the right thing. And I had a letter from an attorney a while back, which I can't get my hands on right now, where they would come in on behalf of Ralph Guild because Ralph wanted that so much to be the way it originally was. And that's
Yeah,
just
I think I attended the dedication of this when it was finished.
Yeah,
So when the dam was finished, when the
Yeah.
pond was finally dredged, and he had to deal with DEP and
oh,
Rhode Island,
Rhode
DEM,
Island, Massachusetts.
and the EPA. So
Yeah,
he spent a fortune.
yeah,
doing this.
absolutely. And so I know. And by the way, also in my research, I found that that's part of why I'm talking about not designating the lots here and what it really covers, is because there's multiple lots in this, and I don't know where the boundaries are from looking at this.
From what I understand, the boundary is at the end of the parking lot.
Yeah, but there's that little house
Yeah.
that's farther to the east, and that was a lantern shop.
Right.
So,
I remember it.
yeah, I vaguely remember it. Anyway, thank you.
Thank you. So lastly, Jerry, are you suggesting that if they're going to hang their hat on the temporary trailer,
Can't hear you.
if they're going to hang their hat on the temporary trailer zoning bylaw, that we have to approve it? correct? Is that what you're saying?
No,
I think you said that, but did you mean
No,
the select board?
no, I'm saying that you can't fit the square peg in the round hole.
No. If it's properly worded,
Oh,
if there's a definition, and this fits in the definition,
absolutely.
so who approves that? Is it us?
No, the zoning enforcement officer. But,
Approves the temporary trailer permit?
no, it wouldn't be a temporary trailer permit. It would be that they're allowed.
By right?
Just allowed, by right.
Okay.
So it would be just like anybody else doing
Yeah.
anything else by right. But Ralph determined that it wasn't. And that's why he did a cease and desist.
Because it's not in the table of use, right? Didn't hear me.
It's also saying that it's in the residential agricultural zone, and it's not conformable.
It wouldn't be the first non-conforming use that we have. It's not permitted, so. Anyway, thank you. So where do we leave off here?
Planners report.
Planners report.
So I've got a flyer up here. It's for one of our events this week. We have a couple coming up on Wednesday and one on Thursday. Tomorrow, the barrier beach planning that we're doing at Atlantic Avenue, East Beach, and the Nubble or Beach Avenue is going to be kicked off in a public virtual meeting tomorrow night. 6 o'clock, it is a virtual meeting, and so you have to, you can register here at serped.org /WBBMP.
So you have to register so that they can send you the link to get in,
Yes,
because otherwise you can't just take a link from here and get in.
that's correct. You have to register, and they've done that as a security means because they've had issues with Zoom meetings getting hijacked essentially by people trying to cause some ruckus on the call, I guess I'll say.
Do you know how many people have registered so far?
We talked about, I met with them yesterday, and it's like 26 so far. And then we have another event the day after. It's for the bike trail that we're designing from the Quequechan River Rail Trail to Old Bedford Road. They've got some nice graphics from this that I'll share with the planning board if you can't make it. But yeah, the graphics look pretty nice, and we want the to get some feedback on the two alternative designs, which if you remember, there was the one that runs along the banks of Watuppa Pond, and the other one would run right along Route 6. Obviously, the one along Watuppa Pond would be a little bit more scenic, but there's more expense associated with that. So we just want to get folks' opinions on which way we should approach it, and we'll keep the project moving. And that's at 6:30 on Thursday. It is in person at the library. And next on the planner's report is our municipal vulnerability preparedness action grant applications. I'm working on 2, definitely going to submit 1. The second one I'm unsure if I'm going to be able to make the deadline because the deadline's next Friday. The first one is to support the climate resilience plan. We've talked about that quite a bit, about getting support from UMass Dartmouth to help draft the plan's contents, and then we'd collaborate with SERPED to do the public engagement to help inform the development of the climate resilience plan document. It would be building off of the efforts that the committee has already put into the plan. We just need a little bit of extra help to keep things moving and get a nice, finalized, polished document together. So that's what that MVP application will be for. The other one is looking at the head of Westport to improve its resilience to floodwaters and stormwater. As we know, the Old County Road Bridge can get overtopped during southerly storm events. There's also some stormwater issues where during high rain events, stormwater can come up through the manhole on the green down there, and we're not sure exactly what the cause of that is. There's also a hole in the ground that's northwest of that location by like 20 feet, and it turns into like a bubbling fountain during high water events. I have a video I can show you.
This is
sometime.
on the green that's on the
Yeah, I mean it's
west side?
it's just like kind of gurgling up. It's not like a fountain, but the water is actually coming out from underneath the ground in that location, and so then it causes ponding in the surrounding area. So it's not helping with the storm and floodwater issue down there. So we want to assess that and come up with some means to fix those issues. I don't know if I'll be able to get to completing the application, but that's the concept, and hopefully I can get it done. I've enlisted the help of Serpent, and I think some consulting engineers will offer some support for some of the sections because they're interested if we get funding to bid on it. So we'll see if we can make the cut on that. And that's it. So there's a discussion about offshore wind, John.
Yeah. Mr. Chair, I'm the Planning Board representative on the Offshore Wind Committee, and we were charged, this committee was created by the Select Board and charged with trying to understand what the impact would be on the town of Westport of offshore wind, and it's chaired by Jake McGuigan, who is the representative from the Conservation Commission and has a number of people on it, both representatives of organizations like Planning Board and Conservation, and also at-large members. And we've been meeting every month. And we had a big meeting at the high school where we heard from Vineyard Offshore, which had listed Westport as an alternative site for cable to come ashore. Their primary site was in Connecticut. And they said very clearly that even though Connecticut wasn't going to buy power, they were not going forward because without Connecticut's purchase agreement, they didn't have the ability to go forward. But if that ever changed, they were still going to land their cable in Connecticut. And they had to file a backup, so they filed Westport as a backup, but their intention is fully to do Connecticut. And it was very nice for them to accept our invitation to come and talk to us, but they have no intention of landing a cable in Westport. And there is, of course, with the new administration, a halt on any project that is not underway. So it seems that in terms of will there be a project that impacts Westport in the foreseeable future, the answer to that question is a pretty clear no. And the Select Board said that this committee is not here to just debate the merits of offshore wind in general. It is about the immediate impacts on Westport. So the hearings that we held, I think, were offered some reasonable information. We had about a half a dozen people from the state who came down who said there is some money available to Westport or any other community that might be affected to hire professional to understand what the impact, because these are big projects, they're complex, and that's good to know should there ever be a project that would impact. But you can watch the video of the last meeting. And I got disturbed because there are some members of this meeting who are, I think, interested in litigating their point of view that offshore wind should just not exist in general. And and the way they go about it is something that as I explained to the chairman, Jake McGuigan, I think is turning this effort into something that is not serious. And I said to Jake that the way the Conservation Commission operates and the way we operate, and tonight was a good example, is that there's a part of the hearing where you listen to engineers or you listen to lawyers, and you listen to people who've earned the right because they have, you know, certificates and to tell you about engineering, because they went to engineering school or traffic engineering, or they're lawyers and you listen to them to counsel because they went to law school. So you listen for their expertise. And then there's a different part of the meeting where you open it up to the public for their opinions. And we can tell the difference between the expertise we rely on, legal, engineering, whatnot, and public opinion. Both are valuable, but it's very important to tell the difference. And what is happening with offshore wind is you get a lot of opinion that's masquerading as expertise. And it's being confused. And it's also bringing in issues about, you know, does offshore wind kill whales and stuff like that. And, you know, we have whales on the beaches, so that must mean offshore wind's killing whales. And, you know, correlation is, you know, basic things like correlation is not causation. And you go down rabbit holes every single meeting. And as I said to Jake, it's not a serious discussion anymore. And personally, I just don't want to lend my name to something that isn't a serious discussion. Every night here, we have serious discussions. This is a circus. It turns into a circus. And so I told Jake I was thinking of resigning. And he said, I understand, John. And then I mentioned to the chairman afterwards, I said, I'm not sure that the planning board should participate anymore. I don't think it's just me. I'm not sure. I mean, this person who continues to bring up opposition to offshore wind has said, I don't trust the planning board, I don't trust the Commonwealth of Massachusetts, I don't trust NOAA. She only is going to trust someone who agrees with her already formed opinions on things. I mean, that's not the way you do science. It's just not the way you do science. And if you got to work with someone who says, well, I don't trust the planning board, I don't want to participate in a forum like that. I mean, that's a clown car. And I just don't have a use for that. There are other things to do with your time. I'd rather watch, you know, Wile E. Coyote chase the Roadrunner than spend time in an arena like that.
I attended that meeting at the high school, and also, that was my understanding of the formation of the committee, was if offshore wind decided to bring power ashore in the town of Westport, namely running up the Route 88 corridor. But if they brought power, offshore wind brought power ashore, what are the impacts of that? That is the onshoring. I mean, and to have I agree with, I listened to this thing about whales are washing up on the beach and whales, you know, the pile driving affects the whales and all this stuff. And all I could think of was absolutely none of that is in the purview of the town of, they, just as a citizen, they can have whatever opinion they want. I'm not taking away their opinion. But when you sit on a committee to look at the impacts in the town of Westport, pile driving in federal waters is not a subject that the town of Westport has any jurisdiction over. Nor is it, once you get beyond the town limits and the immediate offshore. It is, if that power line came ashore on the streets of Westport, what are the impacts? What is the mitigation? What does the town gain out of the mitigation that's possible? And then, you know, to have the committee continue on these rants about, you know, the sort of offshore wind as a general idea is totally opposite to what my thought of the purpose of the meeting is, the purpose of the committee. And you know, I think, as you know, the committee members whose focus is in something that the town has no jurisdiction over, is ill-serving the public, is ill-serving their membership of the committee, it's ill-serving, you know, it's just making speeches about something as opposed to working on the work of the committee, which is, I agree. I've concluded that it is unlikely that the committee has much of a purpose, because it's unlikely that power will come ashore here, because not because Westport isn't a nice place, not because Route 88 isn't straight with a wide corridor. It's that there's no good interconnection point for large amounts of generated power. That's why they're going to Connecticut, because in New London, there is a greater junction of big overhead power distribution that they can distribute the power into New England. And Westport, absent a direct connection to Brayton Point, Westport doesn't have any of those characteristics.
So can I just add, I mean, if John, it sounds like if Vineyard Offshore Wind is no longer, it's no longer a likelihood that they're going to use Westport. They're aiming for Connecticut as their first choice, as they said. So what is there, I mean, I can well understand what those meetings are like. Is there a point to having the committee any further? Or should they not just go into recess and indefinitely until something else comes up that directly affects the town?
I think we should, and I think the chairman may do this. I think he's going to have one more meeting. I connected him with Kevin Stokesbury, who's the dean at SMAS. And SMAS has done a lot of work for a number of years on impacts of offshore wind on the marine environment. And he's a Westport resident, you know, he lives up at Forge Pond Road. And I said, you know, that Kevin could brief the committee on impacts on lobster. Westport's a big lobster port, you know, and other marine resources, and that would be a useful thing to know. And I said a second question that might be useful to know would be if we were able to get more resources from the state, which is what I mentioned. The state said they have a fund. Could SMAS find out more information of particular interest to Westport, oysters or other things like that? But other than that meeting, and Constance Key mentioned a scientist who'd done some work on plastics because of the plastics that came from the blade. And plastic pollution is a big issue no matter what the source is. I mean, plastic pollution is a huge issue. So hearing from that, but other than those two issues, I think the chairman was thinking we should go into an extended recess until there's a project that may impact Westport. But I still think that, and I hope he does that, but I think that we should not participate in this because of the way it's been conducted. Perhaps until there is a project that is going to impact Westport. And I know because I do work in New Bedford with offshore wind through the New Bedford Ocean Cluster, that the wind industry is saying, you know, oh, we're taking 4 years off here. You know, this is going to be a long time. So this may be a long recess.
So, would you like a motion from the planning board to suggest to the select board and to this committee that it be put on hold for, and that we withdraw sending somebody until we have something to do?
Yeah.
So moved.
Second.
All those in favor?
Aye.
And one of you two will draft up something nice?
Nice.
So, assistant planner's report.
Yes, and just right before I share it, I have 2 forms for the board to sign as well, so I'm just going to pass them through. Thank you. One is for the 202 Pine Hill, the partial release of the surety, and the second one is signing off on the Delana food truck. I apologize that I didn't disperse earlier. Onto the report. On March 15th of this past month, the chairman and I attended the annual Citizen Planner Training Collaborative Conference in Worcester. And so I just have 4 small key takeaways that relate directly to public meetings. And I thought it'd be interesting to share. I mean, the board can absorb or just listen. You know, these aren't necessarily recommendations, but number 1, which we do, clearly define the scope of jurisdiction of the board to streamline the conversation. I feel like this is relevant to the food truck conversation that we're not going to be talking about the use. Number 2, board should have alternates. And actually, when talking with chairman and town planner outside of planning board meeting in the office, it was discussed maybe that recommendation isn't super relevant to the planning board specifically, but maybe could be applied to other types of boards. Number 3, I thought that this was really big. Voting on each findings of fact as kind of like an internal check and balance to maintain the integrity of the decision. So I know that that's probably going to add some minutes to each of our motions and decisions, but I think that to me feels like a strong choice to incorporate, voting on each finding of fact, so that, you know, that can be either disputed by the public or even by the board, and then we come to a more...
You mean separately?
Yes. Yeah, I know. But I do see how that kind of strengthens the integrity of the decision of the motion.
No, I agree. I think that's a good idea.
I know that chairman picked up on retaining surety of 40,000 as a good incentive, so that was something he had shared earlier.
Yeah, it was a good call.
Yeah. And then this one is more for me. Just go to a site visit. You know, sometimes I'm looking at a case and I haven't even been there, so it's like go to each site and get a good feel for it. So I'm still kind of learning, you know, Westport's geography. So I think I'm definitely going to apply that more actively. And then my second follow-up, I kind of have already talked to you gentlemen about this, the surety follow-ups. this month I've been reviewing these cases from 2025 back 10 years till 2015 to figure out what's outstanding, what's left in the surety, and what's left in the consultant review funds. So before following up with these applicants, I will provide to you a report on these kind of outstanding items, the status of these cases, so that these next steps can be addressed. We're all on the same page. So, yeah, it's been a busy couple weeks, so I don't have that report ready right now, but it'll be coming soon.
I think you're starting to see more admin items though,
Mhm.
so that's where this is coming
No,
from.
I think that the fact that you are digging back into files and finding things is really incredible.
It's
that
a lot of
you're-
work she's taken on, so, yeah.
I have really good direction, so.
Could I also, at the peril of adding to your burden, just to follow up on something that Amy kept track of, which is the status of the solar, our approvals or denials of solar,
Yeah.
large-scale solar arrays, and which ones have been approved and perhaps not started, construction is not started, or construction is started, or they are complete, just a status report. She has a form that she started.
Yep.
And if you could just update that and make sure
That's-
we're,
Yeah, we'll have that ready for the
That's
next
a-
meeting.
That's a very good suggestion, because we have approved a lot of them. And many of them never start, they don't get their connections. And all of those are special permits, and all the special permits are lapsing. In some cases, they come back to us to get the special permits renewed, but, I think a lot of it varies. I think there's two sort of big stumbling blocks. One of them is getting the Eversource connection permit. That just takes a lot of time. And it takes an analysis of, can you put all this power into our local distribution system, which isn't very strong. And then the second is the fluctuations in the tax benefits and the tax regulations, which drives a lot of the development profitability really rests on a lot of the tax credits that they get for generating the green energy.
So, I agree with that, and I just wanted to add one of the takeaways. I went to this CPTC conference also, and one of them that I went to was permitting renewable energy, and so solar and wind and anything. And the governor has signed a new law that will be effective in 2026 that gives you have to issue a single permit. So I believe, it was a confusing thing, but a single permit. So the planning board and the conservation would have to agree on a single permit on what they have to do. And you have to issue this permit within 1 year. And it can be under the purview of the siting commission, of which we would have a seat, but the rest of them are from the state. And so we really need to have somebody have a deep dive into how this works, because it just was alarming and confusing. So the parameters are, don't cut down trees, don't put it in farmland, put it in rec areas already, put it on roofs, put it on parking lots. Well, we don't have any rec areas, and we don't have many roofs, except for residential. We don't have big parking lots, so woods and farm fields, I mean, seems
Mhm.
like that's what we got. And I don't know how they're gonna handle that, so.
We do actually, since you're talking about it, have an interesting proposal. Well, it's not a proposal yet, but we've been talking with someone about developing a solar canopy over a lot on Forge Road. It would be like a 40,000 square foot
Mhm.
solar canopy. So maybe that'll come forward. I don't know. We haven't seen any plans yet, but I think that would be the town's first large scale
So is this,
solar
is it-
canopy.
is this the owners of the little industrial place on Forge Road? South of-
do you,
south of
can you
the dam?
remember what the address is?
It's 85 Forge.
85 Forge.
It is looked on like MapGeo, there's like cars, it looks like a salvage lot, like an auto salvage lot.
Mhm.
The state could cover all the Hose Neck parking lots.
Think-
And then the seagulls would have a new target to break their cohogs on.
Yes. So, anyway, continue. Are you done?
I'm done.
Okay, I just wanted to put in some of my thoughts about this. And there was I went and listened to a big one on surety,
Mhm.
and that's the one where they really stressed, don't give away the money below $40,000, because you'll never get anybody to finish. So I think we need to make that as a plan.
Yep.
Okay. The other thing that I heard, and I hope that, well, the harbor water supply looks like it's gonna be approved by DEP within a week or two, maybe 3. And after that happens, they're gonna have to find a way to get the water down to the harbor area where their users are. But as part of that, I think we need to be looking for funds to replace the culvert there, the herring run, because it really needs to be a bottomless culvert.
Mm.
And
You set it at the right elevation to let the tide run.
Right.
and let the fish in.
Right.
So, make it a real herring run. So, the way that they're connected is that right now their well is right on the shores of Cocky's Pond, and by letting the tide go in and out like that would really affect the quality of their water. But once they get the new well source up and running, and I think we have to plan for it ahead of time, so.
Is this the River Road culvert you're talking about? Okay.
And secondly, my cousin Sam Whiten texted me the other day, and he's working on a project. He wanted to know if Westport would be interested with Trouts Unlimited. And apparently they want to work on Bread and Cheese Brook rehabilitation for Trouts Unlimited, and I think that's great. I told him, yes, please.
That's a very good idea.
Mhm.
So, minutes, March 11th?
No minutes. Deferred to April
April
22nd.
22nd. Okay. ZBA notice?
We have a notice from the ZBA that's an update of the 1180 American Legion Highway proposal, which is, if you recall, they had an expansion of outdoor use in our site plan application. They were going to have outdoor storage, and so they have approved that application. They don't have to come back to the planning board because we've already seen that iteration of the plan.
And which one is this?
The storage at 1180 American Legion Highway. It was being used as
The old
a,
school, right?
yeah, right.
Oh, that one, way down
Yeah.
there, okay, yeah,
Yep.
yeah, yeah. Okay.
Reducing the parking from 41 to 20.
Yep. Yeah, and they got their approval to do the parking variance as well, yeah.
So has anybody been down to inspect their progress? Are they doing anything down
Not that I know of. We can go over there and see what they're up to. They're probably waiting on this ZBA approval before they could move forward with any other permits.
there? Okay,
Want a motion to adjourn?
I would.
So moved.
Second?
All those in favor?
Aye.
Aye.
Aye.